This presentation will explain to you the 10 common mistakes that can ruin your Wisconsin personal injury claim. Lawyer television ads tout their trial experience and claim they handle serious personal injuries, but they may actually have little or no trial experience. If this is the case, then you can assume the insurance company knows this too. In Wisconsin, it's very difficult to fire your personal injury lawyer and then find another lawyer to represent you. This is because Wisconsin law awards the contingent fee to the first lawyer. The second lawyer is compensated only on an hourly basis. Insurance companies often attempt to convince an injured person to sign a release early on, settling their personal injury case as quickly as possible after an accident. A quick settlement almost always equals less compensation for the injured person. Do not settle your case unless you are sure that the injuries that you have resolved and you will have no problems in the future. Keep in mind that doctors are usually not able or willing to assess a permanent medical condition until at least 6 to 12 months post-accident. A quick settlement prevents an injured person from making a claim for a permanent injury and the costs of any future medical treatment. One of the first things an insurance adjuster will attempt to do following an accident is obtain a recorded statement from everyone involved in the accident. Insurance adjusters receive training for asking questions that will elicit responses in their favor. The most common tactic used by insurance adjusters is to attempt to show that your actions and inactions somehow caused or contributed to the accident. If an insurance adjuster has requested that you give a recorded statement, ask yourself, how will a recorded statement benefit my case? The answer usually is, it will not. Always speak to an attorney for advice before consenting to a recorded statement. In any personal injury case, the injured party has the burden of proving their injury to the jury. This is mainly done through testimony from doctors. If you try to tough it out and wait for your symptoms to resolve before seeing a doctor, then you have just created a very difficult personal injury case to win. If you go into court 2 years after an accident and are claiming a permanent injury, but you didn't see a doctor for the first 2 months following your accident, a jury would be suspect of any claim of permanent injury. As much as many of us hate going to the doctor, the failure of an injured person to timely see the doctor can ruin the case. Some personal injury firms that have high volume practices send most of their clients to a select group of doctors or chiropractors. Although these lawyers know the doctors or chiropractors well, the insurance companies will also know them well. We usually recommend that injury victims first see their primary care physicians and attempt to obtain proper treatment or appropriate referrals. Primary care physicians can be very powerful witnesses because they have known the injury victims before and after the injury. Therefore, they know how the accident has changed the patient's physical condition and quality of life. Sometimes our clients' treating doctors refuse to get involved in the lawsuit. In those situations, it may be necessary to send the client to a doctor willing to get involved in the case. A picture is worth 1,000 words. Photographs of visible injuries such as bruising and cuts can be invaluable in a personal injury case. Oftentimes, the medical records do not adequately and effectively describe the true nature of the injuries. The visible injuries also usually clear up within a few days or weeks, so it is critical that you obtain photographs before it is too late. Also, the property damage to your vehicle should be photographed before the car is repaired or salvaged. Oftentimes, injury victims are reluctant to complain of their pain, hoping that it will get better. Insurance adjusters are trained to ask questions in a manner that encourages injury victims to minimize their symptoms. Doctors can also be reluctant to explore the full extent of the injuries if there is a possibility of becoming a witness in a personal injury case. If you are in pain, you must be honest and forthright about your complaints. One of the most common defenses in any personal injury case is that the injured party was experiencing more pain than they should have experienced, considering the nature of the injury. The defense will imply that the injured person is exaggerating their symptoms in an attempt to get more money. Jurors can be very receptive to this argument, especially in cases where there are claims of injuries that cannot be seen. If there is any documentation that could suggest exaggeration of your symptoms, then you can bet that the insurance company will make it a central part of their case. In describing your symptoms to your doctor, the defense attorney, or the other side at your deposition, be as descriptive and accurate as possible, but never exaggerate. Although one of the most important qualities of a good doctor is the ability to listen, some doctors are not good at it. Most people have experienced the doctor that seems to have already decided on the course of treatment prior to entering the examination room. This behavior can lead an injured person to attempt to get the doctor's attention by exaggerating. This is not a good idea. In today's world, it's quite common for insurance companies to investigate the background of injury victims. Insurance companies routinely hire private investigators to conduct videotape surveillance of injury victims. If you tell the insurance adjuster or your doctor that you are unable to do a specific activity due to your injuries, and there is a videotape of you actually doing the specific activity after the accident, then you can forget about your personal injury claim. You have lost all credibility with the insurance adjuster, and you will have a difficult time convincing a jury that your injury is really as severe as you are claiming. Worse yet, Wisconsin law does not always require the disclosure of this videotape until the time of trial. Many of our clients have been videotaped by the insurance company, but fortunately the videotapes confirmed their complaints, which increased the value of their case. The most common example of failing to disclose all pertinent facts is when clients fail to tell their doctor or their lawyer that they had a prior accident or injury to similar body parts. If the doctor is not aware of this prior problem from the beginning and it is sprung on them from the insurance company or the lawyer, then they inevitably change their opinion. Wisconsin has a very favorable jury instruction on aggravation of a pre-existing medical condition. However, if the injury victim's lawyer is not aware of this prior injury at the onset, then proper case strategies cannot be implemented. To start getting help with your case or to answer questions that you may have, please call Rozek Law Offices at 1-888-A-LAWYER or visit www.rozeklaw.com.